We'll email PowerPoint.
Thank you very much. First and foremost, I want to thank the Irish branch of the Chartered Institute of Arbitrators for the invitation, which I accepted with great pleasure. A special thanks to Mr. Dautaj, who is not here, and Mr. Huluhan, the former who introduced me to the latter, and the latter who introduced me to arbitration. I also want to pay my respect to Mr. Justice Michael Prill, and I am indeed proud and honored to be called to speak alongside such a prominent judge. It is my great pleasure to address you today. Today's speech will constitute a general note on the SCC's introduction of the emergency arbitration. First, I will give a brief background, followed up by an introduction, before discussing the nature, the procedure, and the role of the arbitrator in emergency arbitration. Second, before putting the speech to a glory that was in the past, I will try to put things into context by case analysis, looking at the gist of 3 emergency arbitration cases and one arising in the context of investment treaty arbitration. Third, I will provide you with my reflections, concluding remarks, and ending words. To the background. Before the concept of emergency arbitration was introduced, disputing parties which were to settle the dispute at SCC, which is the Stockholm Chamber of Commerce, could not obtain an interim measure from an arbitrator before the constitution of the tribunal. This was obviously possible in front of the courts. The status quo at time, the rigidity in the procedure of conducting arbitration in a sense, screened for development, as the constitution of arbitral tribunal could take months and there was a risk that one party would suffer irreparable damage in the meantime. In order to mitigate these risks and make interim measures more available when need be, the idea of the emergency arbitrator was introduced. Hence, the parties can now request an interim measure before the constitution of the arbitral tribunal. The SCC is not the only institution which has introduced similar rules. Similar rules have been introduced in Hong Kong, London, Singapore, and other places. By contrast, similar rules have not been introduced by the ICSID arbitration rules and the UNCITRAL rules. The Arbitration Institute of the SCC was founded in 1917 and has since the 70s handled international disputes. Parties ranging over 40 nationalities have chosen SCC as their venue for settling their disputes. The SCC is a venue for international commercial arbitration, investment treaty arbitration, and also mediation. And it is listed in the Energy Charter Treaty for settling disputes between investors and states. In 2010, the SCC introduced the rules on the emergency arbitrator, which became an integral part of their standard rules. Therefore, in light of this development, if there is a need for a prompt interim decision, a party may apply for an emergency arbitrator and receive a decision within only 5 days. Notwithstanding this time frame of 5 days, it can be extended. I will come back to that. An emergency decision is binding on the parties when rendered, but may be revoked by the emergency arbitrator upon the request of a party. An arbitrator or an arbitral tribunal is not bound by the decision or the decisions made by the emergency arbitrator and may decide that the emergency decision or decisions cease to be binding. I will discuss in brief the nature of the emergency arbitration. It has an opt-out mechanism rather than an opt-in one. I will come back to that later and compare. The rules apply to all arbitrations conducted under the SCC rules unless expressly agreed otherwise. The application initiating the emergency arbitration procedure can be made until the case has been referred to an arbitral tribunal. The arbitration agreement is not, per se, an impediment against a court granting interim measures. The relevant legislation, the Swedish legislation, is found in the speech, which will be circulated. There is no possibility of an ex parte decision. Similar there, the articles are found in the speech. The appointment of an arbitrator has to be done within 24 hours, and this is significant, and I will get back to that. And furthermore, the arbitrator may not act as an arbitrator in future arbitrations relating to the dispute unless agreed otherwise. the decision is to be rendered within 5 days, and as I said earlier, may be extended upon the agreement of the parties, which has been done several times. In comparison, the ICC rules, which also have emergency arbitration rules, have a time frame of 15 days. The costs are 15,000 euros and are paid by the applicant. So I will run through the procedure of the emergency arbitration fairly briefly. 1. The claimant's application for appointment of an emergency arbitrator and payment of costs arising from such. 2. The SCC notifies the respondent. This has to be done in a way that gives proof of service. 3. The SCC appoints the emergency arbitrator and sends out his CV and awaits confirmation. 4. The application is referred to the emergency arbitrator. 5. The emergency arbitrator contacts the parties and sets up the timetable. 6. The respondent replies. 7. Claimant submits final comments. 8. The emergency arbitrator reviews written submissions and hears the parties. 9. An emergency decision is rendered within 5 days, unless, as I said earlier, it is extended in agreement between the both parties. So to the powers of the arbitrator. This may not come as a surprise to you, but before the power or role is assigned to the emergency arbitrator, there has to be one. And when choosing the arbitrator, the board considers, among other things, the nature and circumstances of the dispute, the applicable law and the language, the nationality among the disputing parties, and so on and so forth. The powers of the emergency arbitrator is outlined in Article 32, paragraph 1 to 3, which you will also find in the speech and should have been on the PowerPoint behind. But I will read them out to you. 1. The tribunal may, at the request of a party, grant any interim measure it deems appropriate. 2. The arbitral tribunal may order the party requesting an interim measure to provide appropriate security in connection with the measure. And finally, an interim measure shall take the form of an order or an award. This is also relevant in relation to enforcement, and I will come back to that under reflections. Notwithstanding that the arbitrator conducts the arbitration as it considers appropriate, as you're well aware of wearing arbitrator's hats, there exist guidelines, prerequisites for granting a request for an interim relief. It seems to be even harder in the case of emergency arbitration, but that is obviously my take on it. There are 5 prerequisites frequently mentioned in SCC material. Remember, cases are most often confidential, not released, and therefore I refer to the SCC material rather than the cases per se. And these are, inter alia, a prima facie jurisdiction, an established urgency, an established and reasonable possibility to succeed on the merits, prima facie. The request must be appropriate and necessary, and the claimant has established a risk of irreparable harm. The buck doesn't stop there. SCC practice shows that having established all of the above, the request must also be considered necessary and appropriate, which allows for a broader assessment. Not to leave the obvious, for any injunction and/or interim relief, the measure sought must relate to the substantive claims and purport to protect rights subject to proceedings on the merits. In relation to the prerequisites, it must be said that the requirements are not a mechanical checklist, but a foundation upon which the arbitrator forms the view of whether it is necessary and appropriate to grant an interim measure. The parties have, by agreeing to arbitrate under the SCC rules, accepted that the decision is binding on the parties when rendered and to comply with it without delay. This is also to be found in the articles, and you can find those in the speech where relevant. The emergency arbitrator has, however, the possibility of amending or revoking the decision upon request of the parties, which is also important to note. I will run through 3 cases and 1 investor state, just for sake of completeness. Under this heading, there is no need to outline or discuss the procedure step by step, as the standard procedure have been outlined, and there would only be minor deviation, as for instance, rendering the award on the 7th day rather than the 5th. The first case I will mention was between two Swedish companies arising under Swedish law. The dispute regarded a contract that should have been completed on a certain date, and any delays would result in penalties. The claimant requested that the emergency arbitrator should issue an interim declaration that the claimant had the right to postpone completion of the construction by a fixed number of days, and thereby amend the parties' contract that the work should be completed on a later date than previously agreed. Another case, a dispute between Swedish and German parties under the Swedish rules, concerned the alleged unlawful termination of the agreement, and the claimant demanded performance of the respondent's contractual obligations. The respondent counter-argued by saying that its potential performance of the agreement would be illegal under the mandatory laws of 2 other countries. The claimant requested the emergency arbitrator to order the respondent to immediately do one of the following: deliver to the claimant the relevant products and documentation, alternatively store the products and documentation with a neutral third party, alternatively not in any way dispose of or otherwise dissipate or diminish the value of the products or the documentation. In this case, the application for interim relief was rejected. There was neither a risk of irreparable harm, nor did the request meet the test of proportionality. I will come back to the rejection. The third case, also commercial arbitration. The dispute arose around the payment of fees and royalties, which was counterclaimed for damages. The claimant requested that the respondents should immediately comply with 1. Their obligations under the agreement, and 2. Provide access to objects, return objects under forfeiture, obtain necessary licenses and work permits during the removal, and comply with all reasonable instructions. In this case, the emergency arbitrator ordered the respondents to fulfill their responsibilities vis-à-vis the removal and returning of objects. This had furthermore to be performed in good faith. The last case I will mention is an investor state case, which I mentioned just for sake of completeness and to see the difference between the commercial cases and the investor state cases. The respondent contested the jurisdiction, arguing that the rules of emergency arbitration were not an integral part of the treaty between the parties' states at signing, and even if they had later agreed to the rules, the nature of the procedure was such of an extraordinary nature as to require consent given by the parties in advance. The emergency arbitrator referred to Article 31 of the Vienna Convention on the Law of Treaties, which they frequently do in these cases. In other words, that the relevant provision should be interpreted in accordance with its meaning, context, and in light of its object and purpose. The arbitrator stated, and I quote, "When a treaty is formulated in terms whose content is susceptible of evolving over time, it is fair to presume that the contracting states intended their treaty content to evolve accordingly, unless of course there is evidence of contrary intention." This could be compared to the principle of expressio unius exclusio alterius. As seen, investment treaty arbitration is another game, played in the same court and by the same rules of procedure. So, to my reflections. The underlying rationale of emergency arbitrator or emergency facility is not completely novel. Similar ideas have been in place for quite a while. For example, the emergency measures of protection of the American Arbitration Association and the ICC pre-arbitral referee, which allows the parties to apply for a referee for urgent provisional measures in relation to a dispute. However, the big difference with the pre-arbitral referee is its opt-out nature, which essentially leads to less practical effect. Again, that's my note on it. Therefore, one of the fundamental aspects of a perhaps old concept is provided for by the SEC Emergency Arbitration Facility, which applies to all equally unless the parties have expressly opted out of it. On solid reasoning and sound sense, it is perhaps the case that parties are more passive with opt-in solutions due to awareness more than anything else. Some pragmatic concerns. Appointing an arbitrator within 24 hours have indeed practical concerns attached to it. For example, conflict checking, which is a crucial aspect in the selection of an arbitrator, which you're well aware of. Is this something that should or need to be modified in the future? I leave that with you to think about. Another concern is one of enforcement. If an order or decision is rendered, will it be enforced in other jurisdictions? I argue two pragmatic ways of tackling this issue. The first is to raise awareness of the procedure for courts to become familiar with the concept. The second one is, rather than order or render an order, the arbitrator should render an award, which is within the powers of the arbitrator, and in the latter case, the interim measure will be treated under the auspice of the New York Convention. On a personal note, I do like the concept of MEDARB, especially in disputes relating to small and medium enterprises. I know you might ask yourself, what does that have to do with anything? What I mean by ventilating my thoughts on arbitration and ADR from the outset is that the rationale of MEDARB is one of effective early settlements, in best case scenario at least. I propose the same analogy here, or more correctly stated, I argue that it would be a welcomed result if the emergency nature would lead to an effective settlement at an earlier stage. This is far from set in stone, and is for time being perhaps a theoretical reflection more than anything else. So, in a making and breaking kind of scenario, it might be worthwhile knowing what has actually been the reasons for the rejection of an interim measure and how many there has been. The statistics reads as follows, and you can find it at Vinge Humboldt, which is referred to in the speech as well. Rejection due to separately or combined reasons. Lack of urgency, 8 cases. Lack of imminent harm was the reason for the rejection in 7 cases. No jurisdiction to bind third parties, 2 cases. Again, to stress, these have been separately or combined. Another reason is the prima facie claim on the merits in 5 out of 10 unsuccessful cases, and in 2 unsuccessful applications, I will come back to this, undertakings from the respondent. This shows that the emergency arbitrators have applied a rather strict test, which seems to have stood its time, especially in light of, but not limited to, whether the applicant has established urgency and irreparable harm. The vast majority, indeed, have been rejected. For instance, between 2010 and 2004, there were 13 requests and only 2 were granted. A third was partly granted. Glancing at the numbers, one would rationally think that it is perhaps too difficult to obtain a pre-arbitration relief. Notwithstanding this, law is not a numbers game, and each and every issue at dispute must be considered on a case-by-case basis. Furthermore, every case is unique, and there is more than one way to be a successful applicant. Even if it appears to be a rejection on the paper of the order. So, for example, in 2 cases the respondents gave explicit undertakings, and therefore it appears that they themselves seem to accept in whole or in part the relief sought by the applicant. It is interesting to note that there have been parties from all over the world, which can be partly explained, in general, by the very nature of international commercial arbitration. In other words, that parties does not want to go to local courts in foreign jurisdictions. This may perhaps be due to mistrust, and in particular, the element of confidentiality. Again, thank you for your great hospitality. It has been my great pleasure to address you today. I hope I managed to give you a fair overview of the SAC rules and emergency arbitration. I'm sorry that the PowerPoint wasn't working. Personally, I am convinced that the SAC have been a trendsetter and that we are moving rapidly into a new era of dispute resolution. And in any case, any one of you wish to elaborate further upon the emergency arbitration rules and the SAC institution and its rules as such, or the Swedish Arbitration Act or investor-state arbitration, feel free to contact me. My email is enclosed with the speech. I wish you all the best of luck and thank you very much.
Can I take it that Ylli has dazzled you with his brilliance, as a result of which you are in stunned silence and hungry, and then we can proceed to lunch? Does anyone care to ask a question?
Thank you very much. Thank you.
If you repair upstairs, please, for the lunch. Thank you.
Hopefully.